Go ahead and get started. And I want to thank you all so much for joining us today, being here. For those of you who are hoping to receive CLE credit for this session, the information will be shared with you through email tomorrow, and I will also share it with you at the end of the presentation. For now, I'd like to introduce our presenter today, Eric Carlson, the Director of Advocacy and Long-Term Services and Supports at Justice and Aging. He is here today to speak with us about the law and advocacy strategies that can protect Floridians in nursing facilities under Medicare reimbursement. So I will now turn it over to Eric, and thank you for presenting.
Thanks, Nicole. Appreciate it. I'm an attorney, as mentioned, at Justice and Aging. We're a national nonprofit focusing on legal issues, obviously relevant to older Americans, and particularly those with limited financial resources and those who have historically been disadvantaged. I'm here to talk about Medicare and nursing facility issues, and want to start by mentioning an advocacy guide that we make available. It's on the website for a free download, and it's based on the idea that a lot of times there are misstatements, myths, lies, what have you, that are percolating through the nursing facility world. And this guide calls out those problems, these 25 of these common problems, and explains the relevant law and how folks can advocate for their rights using the law to push back against these false statements. And several of these Medicare situations that we'll talk about today are discussed in the advocacy guide as well. And you'll see when we go through this program, some of the points are that your clients will hear things, right? You'll be told this by nursing facility employees or other folks within that world, and they'll say something that they're completely confident, right? That's just how it's always been as far as they're concerned, but what they're saying is actually wrong. And it's important that you understand that, and then when communicating with them or communicating with your clients, you're able to emphasize those points. It takes some backbone to do that, to just confidence in that you're right, and we'll give you the citations as we go through the program, so you'll have the legal authority to back up what you're saying. Here's the first of those misstatements or myths or lies that a lot of times in these situations, facilities and those around them will just assume that certain facilities are only for short stay people. They'll say, well, we just do short stay, we only do rehab, we don't do quote unquote custodial care. And because of that, as soon as you've completed your rehabilitation, for example, or as soon as your Medicaid reimbursement has ended, you're going to have to go elsewhere. You understand, of course. And the answer there is no. That is not true. Facilities don't have the right to force people out under those circumstances. And then the other advocacy warning, the other thing I want to highlight here right at the front end is to point out that therapy shouldn't be limited to Medicare reimbursement. Oftentimes, these nursing facility settings, it's assumed that those are the same things, that as long as Medicare pays, you can get therapy, but then as soon as Medicare stops and you don't get any therapy. That is wrong. And there's a couple of reasons for that. I've listed the regulatory citations here. The first is under the federal nursing facility law, and just to point out, this applies across the country, which allows me to speak to Floridians or people from Massachusetts or Georgia or Missouri or Montana, have this essentially the same conversation because the nursing facility law is the same across the country, applicable to any facility, any resident of any facility, as long as the facility accepts reimbursement from Medicare and or Medicaid, which is just about every nursing facility in the country. There's a very tiny percentage that have such a wealthy clientele that they can afford to turn their backs on Medicare and Medicaid. But like I said, it's a tiny sliver of the facilities out there. So this law is going to apply across the board to facilities. Under that law, a facility has to provide the care that's necessary for a resident to attain or maintain the highest practicable physical, mental, or psychosocial well-being. So if they need therapy, they should get it to reach their highest practicable level of well-being. And then in addition, in a separate regulatory provision, a nursing facility is required to provide services without regard to reimbursement source or to the particular payer. And what that means in practice is there should not be discrimination against Medicaid eligible residents, or there shouldn't be this dramatic drop off when someone transfers from Medicare reimbursement to some other kind of reimbursement, whether it be private pay or Medicaid. So those two provisions together, right? The first is you should get the care to get to the highest practicable level of functioning. That's number one. And then number two, there shouldn't be any discrimination based on payment source. And so that means that you shouldn't have this big drop off, that if you need therapy, you should get it, and it should not be limited to just a few weeks at the front end of your nursing facility stay when Medicare may be paying. Let's start by talking about some basic Medicare coverage facts. These are the rules that dictate Medicare coverage of nursing facility care. So first of all, it's set up as a post-acute benefit. It's not a long-term benefit. I'm sure everybody on this training probably understands that. If you want nursing facility care indefinitely, Medicaid's the public source that's going to cover that. Medicare, by contrast, is designed for post-acute care. You need to have a qualifying prior, at least 3-night stay in a hospital. And then the nursing care that you get in the facility is related to whatever care you received in the hospital. And then usually, and this is a bit of a detail, it has to begin within 30 days of the hospital discharge. As noted here, there's some exceptions here. Like, for example, I guess the most common example would be if you need therapy, but you're not initially in a position to, let's say, physical therapy, to begin physical therapy because you're still recovering from whatever condition or medical procedure you had in the hospital. It can be initiated even after 30 days in the nursing facility, as long as is noted here, it's medically predictable that this qualifying care, in this case, the therapy, will be needed within a predictable period of time. So those are the basic rules. It's post-acute benefit, a qualifying 3-night stay in the hospital, at least a 3-night stay. And then your nursing care or your therapy, whatever it is that you get in the nursing facility, is related to the hospitalization. It's limited to 100 days. Only the first 20 days are paid in full. And then days 21 through 100 have a daily copayment that's currently $204. Goes up a little bit each year based on inflation. So Medicare covers in full for 20 days, and then from days 21 through 100, there'll be what's a significant daily copayment of $204. But the important point here is that it's not a guaranteed 100 days, and to a certain extent, it's a little bit confusing or misleading to focus too much upon the 100 days because most nursing facility residents don't get anywhere close to that under Medicare. The more common reimbursed stay under Medicare in a nursing facility is in the range of 27, 28 days. And relatively few people receive the entire 100-day coverage under Medicare in a nursing facility. And the reason for that is that for all of this coverage, in addition to the requirements that we just discussed, the resident has to be receiving care at a specified level, either skilled nursing services or skilled rehabilitation services, that is therapy, on an everyday or almost everyday basis. So by no means a guarantee of 100 days, you just can get coverage as long as you are deemed to need these skilled nursing services or skilled therapy services, which, as I said, that generally means something more in the range of several weeks or a month or a bit more of that, and in rare circumstances, the entire 100 days. So what are those qualifying services? Let's talk about the nursing services first. It's not just routine, if you will, nursing services. You're in a nursing facility, for example, certainly, and there are nurses there around the clock who are administering medication and doing other tasks. That level of nursing services doesn't qualify you for Medicare coverage. It has to be above and beyond the normal. There's some specific services that are laid out in the Code of Federal Regulations. I've listed a couple here in bullet points. IV injections, for example, or treatment of extensive pressure sores. And then also there's a discussion in the regulation of a more subjective standard that just talks about services, but when the involvement of the nurse is particularly intensive, requires a significantly above average level of skill and attention. For example, development of a care plan when there are numerous difficulties presented, or observation and monitoring of a resident's condition. Again, when there's some very sophisticated judgments that have to be made. In most cases, we just talked about nursing services. Now we're going to talk about rehabilitation services or therapy. And in most cases, this is the justification that allows for the coverage of the nursing facility care under Medicare. That is that most of the Medicare coverage is justified not by the skilled nursing facility, not the skilled nursing services, which I just discussed, which again are part of it, but in most cases it's the therapy services instead that are the foundation for the Medicare reimbursement. So the rehab services are therapy, most commonly physical therapy, but also speech therapy or occupational therapy, and these are performed by a licensed therapist. There are notice requirements here. So first of all, when the nursing facility, when the spell in a nursing facility begins, the facility has an obligation to give a notice of non-coverage if Medicare is not going to cover. This is meant to give the resident a heads up that Medicare isn't covering and that he or she should be conscious of that. And gives the resident a choice. So it says, here's the advanced notice. This decision is being made by us. It's not being made by Medicare. We don't think that the care that you're going to receive here is going to qualify for Medicare coverage. And so the choice is yours, either to get the care and demand that we bill Medicare to get the care without billing Medicare, or to decline services. And then if the resident checks the box that says, I want you to bill Medicare, then the facility has to do that and can't seek payment from the resident until the decision comes back from Medicare. And also, and this is certainly harder to implement, but also if the facility fails to give notice and the resident can say, well, I thought Medicare was going to cover it. The resident can be excused from payment since they didn't know that Medicare would pay. This it's oftentimes unclear how this is operationalized. Who makes this determination? Would come up in a collection action? How would this play out? When I did direct services, I know in one point I did get a determination, when we representing someone, and the case went up through administrative appeals, and we got back a ruling that ultimately said that my client was not entitled to Medicare coverage because supposedly his or her care needs didn't meet the skilled care requirements, the therapy, I believe, in that particular circumstances. But the administrative law judge nonetheless found that the facility was barred from proceeding against the resident based on this provision. Because the facility hadn't given adequate notice, the facility was barred from seeking payment against the resident. So one notice, this is when the resident enters the facility and the facility is giving the notice of non-coverage. There are separate appeal processes which pertain to situations when the Medicare coverage has begun and then stops. A notice of non-coverage before at least a couple days before the end of the coverage, and then the resident has a right for an expedited appeal from the Quality Improvement Organization, and then has a right to appeal beyond that as well, although there's some practical limitations. There's some financial risk, and then also, we'll discuss this in more detail in a second, the appeal is useful only if the qualifying care is provided. So, which is related to the financial risk. And like in the case of therapy, you can get the services. The only way you can win the appeal on these is to have the services provided. But if the service is provided and then you lose, you run some financial risk of being held responsible out of pocket. And then if you're in a situation where your Medicare has been assigned over to a Medicare Advantage plan, it's not identical, but similar. Again, there's this administrative review on relatively short notice, and then a right, if that's unsuccessful, to appeal up the ladder through the Medicare appeals processes, but with some financial risk and with the proviso that the appeal could only be successful if you're seeking coverage for services that were actually provided. Some thoughts on doing this successfully. That I'd say a lot of cases, you don't necessarily get to a appeal. This was again, it's been a while now since I've done direct services. As mentioned, I'm in been in Justice and Aging and national organization for some time now. But when I did do direct services, my experience was that the most important thing was to be strong when the issue was presented. The facility is going to say, Medicare's not going to cover anymore. And that was when the advocate, the resident's family need to speak to the physician or to the therapist and to make the case. Oftentimes, the therapist feels aggrieved by these protections as well, by these not the protections, but by these procedures as well, by these problems. They don't want to be in a situation where coverage is refused, and they don't want to see um, their therapy work just being cut off for no reason right in the middle when there's more to be accomplished. And so my experience has been that it's really important to talk to the physician, talk to the therapist. Just in a couple minutes, we'll talk about this plateauing issue that oftentimes is in play here. Present the law to them, encourage them to be more aggressive, and and to promise to suggest that if they just follow their medical judgment, right, that you will handle the reimbursement coverage legal side of things as much as possible. That in these situations, there's such groupthink, and there's such pressure on people in the system to be cautious um, and to deny requests for coverage. You might think, because Medicare reimbursement is attractive to facilities, it's their highest level of reimbursement, you would think that they would be more aggressive in seeking out Medicare coverage, but there is some significant level of pressure that's coming back from the Medicare contractors, discouraging requests for coverage, and putting pressure on people within the system to terminate the coverage sooner rather than later. So your job, our job as advocates, is to make the case in the other direction. Point out the reality, the importance of the skilled nursing services or the therapy services to your client, and again, appealing to the medical judgment of the physicians and the therapists, suggesting to them that they shouldn't let their medical judgment be compromised by this pressure within the system, and as much as possible, depending on your role, suggesting that you're able to assist with some of these legal issues. And we'll talk about the legal provisions here in a second. This is the first one, and likely the most common one, this issue of supposed lack of progress, which oftentimes is expressed in the concept of plateauing. So the false statement from the facility or someone else within the system, they'll say, we're really sorry, but Medicare won't pay any longer because you're not making any progress. You're plateaued in your therapy. When you hear that language, lack of progress, plateauing, your ears should perk up and recognize that this is something that is incorrect. Improvement is not required under the Medicare law. The deciding factor is whether the therapy is appropriate. Right? Is it necessary? You don't want to provide therapy that's futile. That obviously shouldn't be covered, but you shouldn't be in this situation where your client feels obligated to document progress, continual progress, maybe daily progress, progress from in rehabilitation doesn't necessarily work like that. And in any case, as we'll discuss here, progress isn't necessary under the regulations either. I'll mention this case of Jimmo versus Sebelius. It relies on a regulatory right. Let's discuss the regulation first and then talk about the litigation. The regulatory language here is on the slide in this brown orange color. The regulation has been there forever. And it says that the restoration potential is not the deciding factor in determining whether skilled services are needed. even if full recovery or medical improvement is not possible, right? A patient may need skilled services to prevent further deterioration or preserve current capabilities. So it's not required that you document progress. It's possible that therapy might be necessary just to maintain someone's current condition or to moderate the decline that the person may otherwise experience. The JIMO litigation is more recent, brought by Center for Medicare Advocacy, local legal services, and the allegation of the litigation was that due to the CMS system, to their administration of the program, this regulation wasn't being honored. CMS ended up settling, and because of that, this right to provide coverage even without documented progress is memorialized in multiple Medicare manuals and in other guidance that CMS is issued. And as I'll give you the citation for this in a slide or two. There's a specific web page that CMS has put together that includes all this information, that documents the fact that progress is not required, and that coverage can't be declined for so-called plateauing. This remains a work in progress, that despite the really important JIMO litigation, and despite this regulatory language, you will still hear in practice oftentimes folks in nursing facilities and the other system talking about plateauing or lack of progress. So our job to push back against that, to do some education, and in this individual advocacy to point out that that's wrong, to point out on the medical side or on the clinical side that, of course, when you're rehabbing from something, particularly if you're talking about a nursing facility population, folks who may be in their 70s or 80s, if they're recovering from a broken hip, for example, or something else, that progress is not necessarily going to be this straight line going up. There's going to be some ups and downs, and people shouldn't have coverage declined just because, for example, they don't show any particular progress. Let's say the number of feet that you're able to walk unassisted, just because that stays stable or maybe even goes down a bit over a course of a few days or a week or two, that shouldn't mean that therapy is discontinued. As I mentioned, when you do this, you do want to talk with the therapist and the physician. If you lose them, you're in real trouble. If a physician doesn't order the therapy, that then you don't have anything to appeal. So one of the first and most important things is to make sure that the physician is still on board. And then once he or she continues to order the therapy, then you're in a much better position. As I started saying a couple of minutes ago, this oftentimes doesn't go to appeal. I think as direct service, my experience has been that you get these notices of lack of progress or termination of Medicare covered services. Oftentimes, advocacy within the facility leads to the facility flip-flopping and the physician ordering maybe another week or two, and then going through that and then revisiting the situation 2 weeks later and going through the process again. So that has been my experience. And a lot of times this advocacy is won at that level by pushing back, getting the physician to reverse himself or herself, and then going forward. But recognizing that oftentimes, winning the battle doesn't mean you've won it forever. It means that you're going to have that same discussion a couple of weeks later, When again, you're gonna, maybe your client's condition has changed a bit. Maybe it's a slightly different conversation 2 weeks later. But in any case, it's an ongoing discussion about the appropriateness of therapy and the accessibility of Medicare coverage under the circumstances. So the you talk to the physician, talk to the therapist, get their support, establish yourself as an ally as much as possible. Take a look at our guide, 25 Common Nursing Home Problems, and how to resolve them, discussion these Medicare issues there, and then also cite JIMO info, the JIMO versus Sebelius litigation. You can get that from the CMS website and also from the Center for Medicare Advocacy. And here are the URLs for that, for the federal website, yeah, and some of the federal guidance that I mentioned. So that's the coverage info. Let's look at a related issue. This is the issue, which is a complication of the coverage criteria that I just discussed about whether the person is considered an inpatient or not in the hospital. We talked about the 3-night qualifying stay. That only applies if the person is in the hospital as an inpatient. And as it turns out, and some people are surprised by this, sometimes hospital stays are not inpatient. They're instead essentially on an outpatient basis under observation status, and observation status can continue for multiple days. And particularly in the past, but still in the present, people were blindsided by this when they say they're in the hospital for 4 or 5 nights, assume that the nursing facility coverage might be available to them, and then are baffled by finding out subsequently, too late, that much or all their hospital stay had been classified as observation status rather than inpatient, thus making Medicare coverage unavailable. There's been some changes in this area to address that problem, not perfectly address it, but address it a bit. The hospital has to issue these Medicare outpatient observation notice. The acronym is MOON, MOON. If the outpatient services, outpatient observation status lasts more than 24 hours. And then there's been some litigation as well. Center for Medicare Advocacy has been leading this. We've been co-counsel as well, along with private counsel and other organizations. Initially, there was a flat out challenge to this, to the existence of observation status itself. Essentially, that was unsuccessful. And then the subsequent litigation was partially successful. This was focused on the argument that there had to be some due process rights provided to hospital patients in these situations, arguing that they should be able to appeal determinations of observation status versus inpatient status. I said it was partially successful. That's because ultimately the court ruled that there was not a right to appeal, didn't have due process rights if this for this initial determination, because it was made by a physician and was not subject to any sort of due process requirements. But the court did rule that there is a due process right if the resident, the hospital patient rather, was initially admitted as an inpatient, but then had a status changed to observation. Unfortunately, those appeal rights are not yet formalized. The court ruling is a couple years old, and CMS is working on developing regulations. I've listed the citation here for the Federal Register citation of the proposed regulation. There was some sort of status conference with the litigation in the relatively recent past where the court push the federal government further. And because of that, we can anticipate that these procedures will likely be formalized probably, I would guess, by the end of next year at least. But again, that's something for the future, not the present. So let's transition here and talk about after the Medicare covers. So up to this point, we've been talking about will Medicare cover or not? Under what circumstances? What are the appeal rights? Now we're going to talk about advocacy based on what the nursing facility might attempt to do after the person has exited Medicare coverage. The problem goes back to that advocacy warning that I made in slide 4 or 5 right at the beginning of this program. A lot of facilities try to establish themselves as just short stay facilities. What they're saying is, we just like Medicare. We like this high level of reimbursement, and our business model advises us to bring in people under Medicare, take advantage of that high level of reimbursement. But then once these folks' Medicare coverage ends, right, after just several weeks, probably, we want to force them out and then bring in new Medicare reimbursed people, because that's the most profitable business model for our facility. So they present that to their residents, saying that it's just the nature of their specialization. That's they're just set up to solely for Medicare. They'll say that the person has to leave because they're in a quote unquote Medicare room, Medicare bed, but they're not eligible for Medicare anymore. So supposedly they have to leave. All of that is wrong, as laid out here. The facility says you have to leave your quote unquote Medicare bed. That is not true. A Medicare bed, that terminology, doesn't mean that that bed or room is limited, exclusive for Medicare reimbursement. It just means that it can be used for Medicare reimbursement. Medicare certification under the federal law can be limited within a facility. So a nursing facility can, if it wants Medicare certification, can certify the entirety of the facility for Medicare, or it can choose to certify a so-called distinct part only for Medicare. But that doesn't mean that you can't be in that room with other forms of reimbursement instead. So, for example, you could always pay out of pocket, for example. So now the room is not limited to Medicare reimbursement. You can pay privately, you can pay through private third-party insurance, and you can pay through Medicaid as well. Although, and I'll have to defer to you in Florida as to the Medicaid rules in Florida, because this will vary from state to state. In most states, if a facility is certified for Medicaid, it's certified across the board, and any room in the facility could be accessed for Medicaid reimbursement. There are, however, and because I'm not in Florida, I can't speak to this. I'll defer to you. Maybe in the question and answer, somebody wants to bring it up, or someone wants to post it right now. There are some states that allow facilities to have distinct parts in Medicaid as well. And in that case, there's a little bit of a complication here as to whether the person is in a room that could be accessed for Medicaid. But I will say that even if, just assuming that you're in a state that allows for distinct part Medicaid as well, that doesn't mean you should abandon the facility if the facility says you're not, I'm sorry, you're in the wrong room. What you want to do instead is to put it back on the facility and say, well, you put me in the right room. If you say I'm in the wrong room, I want you to put me in the right room. You have the ability to do that. I've made this request here. And if you If you fail to do that, you shouldn't be coming back later claiming that you can't get paid, because if you can't get paid, it's your own fault for not putting me in the right place. So that's the issue on these so-called distinct parts. The basic point here is that Medicare certification, Medicare room does not mean that the person cannot access other forms of reimbursement in that room. There's some other protections as well, that the resident can refuse a transfer within the facility if the reason for the transfer is to move the resident out of a Medicare certified room. So that's a reason the resident could just say, I refuse to go, right? Here's this regulatory citation. You're saying I have to move out of the room because I'm no longer certified for Medicare. That's not allowed in the regulation. And also, since we're having this conversation, point out that the facility also cannot transfer someone within the facility solely for the convenience of staff. The facility has to give a written notice. So there's no appeal rights here, but I encourage people to, there's no appeal process. The process instead should be that the resident just says, I'm not going. You can give me a notice. I've received your notice. I am not consenting to that, and pointing out that there's a reason for this. You don't want people just being shuttled around for unnecessary reasons. This is where people are living, at least for the short term and maybe for the long term. And the facility shouldn't be just jerking them from one room to another. That's the regulatory right, and the residents have the absolute veto power in these situations to say, no, you're threatening to move me, you're proposing to move for an illegitimate reason. I say no. You will get also not just statements from the facility that you have to leave the room, but oftentimes that you'll have to leave the facility. Facility says you need to leave. The answer to that is no, for the reasons that I just described. You have a right to stay under a different form of reimbursement. Facilities can't limit themselves to only Medicare reimbursement. They can't, it shouldn't be discriminating based on source of payment like that. And procedurally, that's not how evictions work in a nursing facility. A facility has to give notice, and the resident has a right to request administrative hearing. It's just important to recognize there's Medicare notices and there's also eviction notices. There's coverage determinations and there are eviction determinations. Two separate things. And the fact that the facility may comply with the Medicare requirements doesn't mean that it's required with the eviction requirements. And the eviction from a nursing facility can only be done by a facility if it meets one of these 6 standards. The first 2 relate to high level of care, right? You don't need a nursing facility any longer, or you need care that can't be provided in a nursing facility. That's essentially number 1 or 2. 3 or 4, you're endangering other people's safety or health. 5, non-payment, facilities going out of business. Number 6 is closing. So those are the only reasons that a facility can use to force somebody out of a nursing facility. There generally has to be written notice, at least, well, there always has to be written notice. It generally has to be 30 days prior to the date of the proposed eviction. There's some exceptions to that. And one of those exceptions is if the person has been in the facility for less than 30 days. But in that case, you still have to give notice. It just can be given at a practicable time rather than 30 days out. The notice has to list the reason, one of those 6 reasons I just mentioned a minute ago, the effective date. We expect you to leave by X date, whatever it is. We propose to send you to nursing facility number 2, for example, or wherever, or some other location as the facility chooses, but which has to be appropriate. The notice of your appeal rights, you have a right to administrative hearing, and then the contact information for the ombudsman program or protection and advocacy, disability rights, Florida, for example, depending on the resident. So because of all these rules and protections, the upshot is that a resident should not be forced out when the short stay Medicare has terminated, the resident has a right to stay under some different form of payment, either out of pocket or Medicaid. And if the facility really thinks they have the right to force somebody out, they have to go through the process. If they fail to do that, the resident needs to point that out and can always just assert his or her right to an administrative hearing. And one of the defenses to that administrative hearing would be the facility didn't follow the procedural requirements, didn't give the proper notice, didn't do the discharge planning, didn't list an appropriate place of discharge, all those things that I just mentioned a slide or two back. The most important thing, and most cases are lost. If cases are lost, most of them are not lost because they go to a hearing and the resident loses. Most cases are lost because residents just panic. They feel the pressure, and they panic. They rationalize to themselves that if the facility doesn't want them, then they don't want to be there. I argue against it. I get it that I'm not living in the facility, so my client is feeling some pressure that I don't feel. But I also, again, when I did direct services, represented dozens of people, many dozens of people in these eviction cases, and they win. And when they win, they stay, and they do just fine. And the true facility treats them better because they have stood up for themselves and won. I just don't think you're doing yourself any favor by picking up and moving. There's no guarantee the facility number 2 is going to be any better. I think if you really want to go to facility number 2, that's one thing, but don't go because the whole process scares you too much. You're better off standing up for yourself and then being treated with more respect. The facilities oftentimes, particularly in situations like this, just don't have good arguments. Like as I've explained for the last 40 plus minutes, that these are not grounds for eviction. The facilities don't have a right to focus obsessively on Medicare reimbursement. These are human beings, and your goal from a facility to maximize your reimbursement can't be done by tossing people out so casually. They have rights under the eviction rules. They're really strong. The facility can only force people out in relatively rare circumstances. The idea is that residents should be able to get some sense of stability and to stay there if they choose to stay there. And so if they do stay in these circumstances, and are able to say, I'm not leaving, I hear what you're saying, but you're wrong, there's a very good chance that the facility will back off, or if they don't back off, that the resident will win in the administrative hearing. So with that, I'll obviously finish up the prepared discussion here. I'm happy to field any questions that may have come in. And I'll also say that on behalf of Justice and Aging, we appreciate the opportunity to come here and to speak. We really thank all of you for doing the really important work that you're doing. And so, the support that you provide to your clients is so important. They feel this pressure. They feel like they're by themselves. And if you're able to support them and give them this information and provide representation as appropriate, it can be such an important thing about improving things for those people, those specific clients, and just improving things systemically as well. Here's my email address. If I can be of any use down the road, feel free to give me a call or shoot me an email. Same thing goes for my colleagues. We want to help.
Thank you so much, Eric, for that very informative presentation. I know this is a very important topic related to our partnership with Florida Health Justice Project's partnership with the Long-Term Care Ombudsman Program and Department of Elder Affairs. So thank you for that. I do see that we have one question related to the 6 justifications of for eviction. I guess just to go over that briefly, or I could, and I could also put that in the chat
Yeah, I
as
mean,
well.
that I'm happy to talk. I've got the question and answer open here as well. I see it's fairly straightforward. There's 6 justifications for eviction from a nursing facility under the federal nursing home law. 2 of them relate to level of care. So essentially, you can be forced out of a nursing facility if you don't need nursing facility care any longer, right? Your level of care is below what a nursing facility is set up to provide. You just don't need a nursing facility. Or the other one is that you need more than a nursing facility can provide, right? Your care needs exceed what can be provided by a nursing facility. That's 2 of them. Then another 2 are you're supposedly endangering the health of other people in the facility, or you're endangering the safety of other people in the facility. And that's 3 and 4. Number 5 is there's not payment of some sort. The facility isn't getting paid for the services that it's providing. And then number 6 is the facility is closing. It's not going to be operating as a nursing facility anymore. Those are the 6 reasons. I'll mention here that I think from a direct services perspective, what you get here usually, you get non-payment cases, and they are what they are. And sometimes there's Medicaid disputes that get involved here. But I'd say the majority of the cases that I would see would relate to either to talk about the client. It's just a client that's difficult for the nursing facility for some reason. That their personality's bothersome, they require a lot of care, maybe they have some dementia, they're calling out at night, they're sort of bothering the other residents, or they're difficult for staff, and they're usually Medicaid reimbursed as well. That's just a general constellation of reasons, something like that. And then the facility says, I mean, we're tired of this person. Not that much money. It requires a lot of attention. Maybe there's a personality dispute as well with the resident or somebody in their family. The facility says, we don't want to deal with this person anymore. And they try to cram that case into you need more than a nursing facility can provide, or you're endangering safety or health. And our job as advocates is to say, that doesn't meet the standards, that being difficult, either by requiring a little bit more care or being personally difficult for whatever reason, doesn't mean that the nursing facility is unable to provide the care. And the reality is so they usually have no real case. That this person doesn't need a locked psychiatric facility or anything like that. The reality is that the nursing facility is set up to provide care for people exactly like this, right? If you've got dementia, well, that's what nursing facilities are supposed to do. They're supposed to provide dementia care. And those are the kind of defenses that you make as an advocate. And you say, the facility, rather than trying to come up with justifications like this, should instead be doing assessment and care planning and figuring out providing the care that's necessary. I'll mention here, we do have a toolbox for these nursing facility eviction, transfer, discharge cases. Go to Justice and Aging, click through to health and nursing facility. There is this toolkit on evictions. It gives some sample administrative hearing briefs and some other materials as well, discussing in more depth some of these common issues.
Great, well, thank you. That was very informative, and hopefully that fully answered the question. I believe it did. And so I know we're wrapping up here, and almost hitting the 1 o'clock hour. So I think we could probably take one more question. So feel free to drop that in the Q&A if anyone has one. Otherwise, in the meantime, I'm just gonna quickly share the CLE information. The course number is 241 241-0886N as in Nancy, 241-0886N. And I will drop that in the chat momentarily. And while seeing if we have any other questions come in, just a reminder that FHJP will also be hosting another webinar next Tuesday, the 22nd, Hot Topics in Medicaid Appeals and Eligibility. We have received CLE approval for that session as well. So please register if you haven't already, and I can provide that registration link in the chat too. But feel free to ask any other questions. I know we're going to wrap up in just a few minutes here. And again, thank you so much, Eric, for taking the time to share all of this information. I know it's a lot, but I think it's incredibly informative and will help, help our advocates here in the state.
Sure, my pleasure.
Well, if there's nothing else, then I think we'll wrap it up. Thank you again. I appreciate you taking the time.
Absolutely. Again, I'm happy to do it.
Thank you. Have a good one. Bye, everyone.